Okay, so we will get started in our workshop today. Welcome everyone to the North Shore Women's Center's Separation Workshop. Thank you so much for joining us today as we explore the emotional, legal, and financial implications of separation from an intimate partner relationship. My name is Michelle Dodds. I'm the Executive Director of the North Shore Women's Center, and I'm joined today by my colleague, Tanya Bacchus, who's here. She's the center's program coordinator, and both of us will be monitoring the workshop as it progresses this evening. Our workshop today is being recorded for the benefit of being able to access the material at a later occasion. And for this reason, the cameras and the microphones have been turned off for all participants, but feel free to ask questions through the chat function. We won't use any names or any identifying information during our responses, so please feel free to go ahead and ask the question as you need to. If at any time during the workshop you need to leave for safety reasons or otherwise, please don't hesitate to do so. As well, I wanted to mention that the material we'll be discussing today is sensitive and it might not be appropriate for children or others in your family. So please make sure that you are in a comfortable and safe place so that you can fully participate on the call today. You can ask for clarification or support through the chat function at any time during the workshop. We're really pleased today to be having some wonderful presenters to join us on this workshop, and they're each going to take a turn in presenting some material, and then there's going to be a specific question and answer period afterwards. So if you didn't get an opportunity to ask a question before the workshop, or if one comes to you while the material is being presented, please feel free to go ahead and ask the question in the chat function, and we'll try to get to all the questions at the end. I did also want to just take a moment to thank our funders for this workshop, which is the West Vancouver Foundation. And I'll mention it again at the end of the workshop, but we will be hosting as well a 10-week separation support group. So we don't have an exact date for that, but hope that it will be starting later in June. So we'll be able to provide you more information later on, but feel free to consider joining that workshop as well. So without any further ado, I'm going to introduce all of our presenters for this evening. Our first presenter will be Carolina De Morris. She is a certified wellness counselor and a life skills coach. She is a professional with 15 years of experience working in corporations and in nonprofit organizations. She's also a co-founder of the International Happiness Conference and Happiness Study Center. Carolina has trained in cognitive behavioral therapy, dialectical behavior therapy, narrative therapy, and in the use of therapeutic reenactments to improve mental and emotional health. She also combines counseling therapies and coaching methodologies with a powerful self-discovery system called Enneagram, she'll correct me on the pronunciation, helping women improve their self-esteem and personal relationships. And Carolina has been the facilitator of our separation support group last year. Our next presenter will be Phylllis Kenney. Phylllis graduated from UBC Law School in 1984 and worked in Trail, BC for 4 years before coming to Vancouver to practice family law. She has left her practice now to join the Child and Youth Legal Center in Vancouver, which provides free legal services to children and youth under the age of 19 years. Phylllis has worked with lawyers and mental health professionals to establish a collaborative practice group, with lawyers and mental health professionals to establish a parenting coordinators group. She has maintained a long professional interest in the impact of chronic conflict on children and the benefit of out-of-court settlements or negotiation, and the need for children's voices to be heard. Phylllis has volunteered for pro bono legal services at the North Shore Women's Centre now for the past 20 years. So we're really lucky to have her. And Madhu Kanwar is our final presenter. Madhu has over 15 years of financial planning experience, having worked as a financial planner with CIBC and RBC. After her own divorce, she started Elixir Consulting to work with individuals and couples going through separation. Madhu is a chartered financial divorce specialist, a certified financial planner, has an MBA, and holds a CFA charter. She has been interviewed for Omni TV show Women in Focus and has been interviewed and quoted by Advisor Today. So we are so pleased to have so much skills and experience at this workshop today. And we are certain that they will be able to provide you with lots of information. And again, please feel free to ask further questions in the chat. So I will now turn it over to Carolina. Thank you very much.
Thank you, Michelle. Thank you very much for inviting me, for being part of this group of professionals with the mission to support the women in our community. I'm very happy and I'm very glad that we offered other separation support group. As Michelle mentioned, my name is Caroline de Moraes. I'm a wellness counselor and life skills coach, and I have been working supporting women and coaching women for many years. My goal today is to share a little bit about my knowledge, about my experience supporting women to deal with hard emotions in difficult times. So I would like to share my screen. Is it possible, Tanya? I think. Okay, is it?
Yes, it should be okay because I stopped sharing.
Okay, no problem. So I have several clients and friends that are going through breakup or divorce in this moment. And as you can imagine, separation can be one of the most painful situations in life. And when a breakup starts, for example, we have our whole world can turn upside down and trigger all sorts of emotions. And my reflection for you today is why, let me share my screen. Okay. Why are separations so painful? So as I mentioned, the separation can trigger all sorts of painful emotions such as anger, sadness, fear, and all these feelings make sense, right? Because we are experiencing many losses, such as the loss of the partnership, commitments, dreams, the loss of our routine, the loss of the relationship with extended family and friends in some cases, and loss of financial, emotional, social support. So it's a lot to manage, right? And sometimes a breakup brings also uncertainty related to the future, and then fear can up. It's a lot to manage. Now imagine to face all this situation in the middle of a pandemic, right? So how stressful could be, how stressful could the situation be? Being very honest with you can be very stressful. So let's see some factors. Many women are at home alone or living with their children alone or living with the partner that they don't want to live with. Online communication may be their only connection with the outside world, and depending on the case, because in some cases we have abusive relationship, for example, they may be very careful when using this kind of technology. And many women feel guilty asking for support because all of us, we are in trouble in this moment, right? And then they feel guilt for asking for help. So if you are facing this kind of situation, I can imagine how deep, how profound is the feelings of disappointment, the feelings of isolation, right? Because the current context may intensify these kinds of feelings, the feelings of isolation, for example. And sometimes isolation is the opposite of someone needs in order to cope with divorce. In fact, we don't have access in this moment to many activities that we can use as coping mechanism during the divorce. Even now that the rules are more flexible, people, they are afraid to go outside. So what I want to validate it here is that the current situation may intensify all these feelings and many activities, for example, that we don't have access to cope with divorce, such as going out with the friends, getting a massage, engaging in a retail therapy, and sometimes finding a new relationship. This kind of activities can help us to cope with divorce. So if you are in this moment in your life, you are probably, as I mentioned, experiencing a profound feelings of disappointment, stress, and grief. And all this pain means that recovery can take time. Recovery can be difficult. However, it's very important, and this is my main message for you. It's very important to keep reminding yourself that you can and will get through this difficult experience and even move on with a renewed sense of hope, purpose, and optimism. Try to remind this, remember that your situation will get better, okay? So this is my main message for you. And now, to help you, to support you, to help you to take care of yourself in this hard moment, I would like to share some actions that you can take to support yourself, some tips and some coping techniques for helping, okay, for you to support yourself in this moment. The first one, recognize that it's okay to have different feelings. It's okay to feel disappointed, confused, exhausted, stress. It's okay. This is normal because this situation, it's hard. And my recommendation, my suggestion for you is try to identify your emotions, tell out loud for yourself. So now in this moment, what I'm feeling is sadness. I am sad, and this makes sense. Try to identify the sadness in your body and validate it. I mean, stop for a moment, connect it with yourself and validate it. Okay, this is the feeling, this is what am I experiencing right now. And after that, try to find a way to express your emotions. You can, for example, journaling or talk with a friend or cry if you want. Because this is part of the healing process. Emotions are energy, and then we need to move the emotions inside of us. Even if the fear of the feeling is so intense, remember that they won't last forever, because this is a specific moment of your life, and your situation be better. So try to express your emotions if possible. This is very important for the healing process. The second action that you can take is give yourself a break. Don't be hard with yourself, don't try to push yourself too much, for example, to being productive the way as you function, the way that you always function, because if now you are going slower, it's okay. If it's not possible for you being able to take care of others the same way, the exact way that you used to, it's okay as well. Give yourself a break. The action number 3 is don't go through this alone. If possible, share your situation, share your feelings with someone that you trust, with a friend, if someone of your family, don't go through this alone, because when you share what is going on for you, you are moving the emotions as well, you are validating the situation. 4, consider joining an online support group. As Michelle mentioned, we will, North Shore Women's Center will offer an online support group later, and then this is a good opportunity for you to share with other women what is going on in your life, and with women that are facing a similar situation. It's a good moment for you to find for resources, support, and share your feelings, and also listen to women who are experiencing the same situation or similar situation. 5, remind yourself, and this is very important, remind yourself that you still have a future, because when a relationship break up, sometimes break up our dreams as well, the plans that we have. So remind yourself that new plans and new dreams probably will replace the old ones. 6, believe in yourself. You know, human being, we have a beautiful capacity for being resilient. Resilience is amazing capacity. It's our capacity to overcome the challenges, you know. And I have been working with the women who suffered severe traumas in the past and recent traumas, and they have shown an amazing capacity for overcome the challenge, you know, and find balance in their lives. And the last one, the last action that you can take, no worries, because we will share this presentation with you. We will send to your email. The last action is, now is the moment to take care of yourself. Now is better than ever, you know, to take care of yourself. And I would like to share 3 actions, tips that you can take to take care of yourself in this moment. The first one, relaxation exercises. So many researchers around the world, they show the benefit of slow breathing and meditation, you know, to reduce stress and anxiety. Slow breathing, I used to say to my clients, slow breathing for everything. You know, sometimes you are super nervous or stressed, you have a lot of legal papers to deal with, you have to take care of your children. So divorce, it's super complicated. And then slow breathing can help you to reduce your level of anxiety and stress. Okay, if you search on Google some information about slow breathing and meditation, you'll find many tips how you can do it. So try to engage in activities that have helped you in the past. You know, even if the external situation is completely different in this moment. Of course, what you are feeling, probably it's intense, but inside of you, what you are experiencing is fear, sadness, and anger. And probably this is not the first time in your life that you're experiencing these hard emotions. So try to engage in activities, look to the past, and try to engage in these activities that helped you, okay? And my last tip for you is reduce time consuming news. Because when we are, for example, we are watching TV and then we have a thought that we are not safe. This thought can drive an emotion, a hard emotion, fear, for example. And then if you reduce the consumption of news, you are helping yourself to feel more balanced, okay? So guys, that's it that I would like to share with you today. If you have any question, you can post it here and I will answer you at the end of the presentation. And thank you very much for your time.
Thank you so much, Carolina. That was wonderful. And I think really highlights the importance of the, as you were saying, the emotional part. When we think of separation, often we tend to think immediately of the legal and the business side, which is all very important, but equally important is first being able to, as you said, identify those emotions that are perhaps influencing our decisions, and being able to find some support in addressing those. So thank you so much for that. Phyllis, can we now move on to your presentation? Thank you.
I'll just be loading it up here for Phyllis. Give me just a moment.
Here we go. That seems to be working.
I think so.
Okay. I'd like to start my presentation by giving my thanks to a number of people and groups. I'd like to first of all thank Tanya, who has provided me up to the very last minute a lot of advice and technical support to be here and participate today. So I really can't thank Tanya enough. I'd like to thank Michelle, who I've known for 20 years, who's been the executive director of the Women's Center and has always been thinking forward with respect to making these kinds of presentations possible for a great number of people. I'd like to thank the Tsleil-Waututh, Musqueam, and Squamish nations for allowing us to be uninvited guests under on their traditional unceded territories today. I'd like to thank Carolina, whose words of wisdom were really a great entryway into my presentation. The one thing that I've found as a lawyer who's worked in divorce and separation for many, many years is that people often don't have a plan or don't think of making a plan. They separate in a great deal of chaos and walk out the door, or do other sorts of very horrible things, and they don't have a plan for what's going to happen as far as their family, their property, or any other really important issues that I have to deal with. So I think that the encouragement that I found from Carolina's presentation is that you have to take care of yourself before you can engage in the business of going through separation and divorce. And if you take care of yourself, you're going to be better able to engage in the business of separating. One colleague of mine who has worked in this area longer than I have has said that so many people don't make plans for separation the way they would make plans for a vacation. So if you can imagine thinking one day, I'm going to go on vacation, and then going to the airport and saying, I'd like 2 tickets to Maui, without a consideration for taking the time off work, who's going to accompany you, what goods are you going to take with you, can you afford this? These are the kinds of things you have to think about when you're going through a divorce and separation. And a healthy client is my favorite client to work with. Legal services, I don't need to tell you, are expensive, and you have to use that resource very wisely if you're going to hire a lawyer. And so the North Shore Women's Center and myself have been working hard to give you lists of alternative resources that are available to you at sometimes little or no cost at all. You have to inform yourself. You have to be unafraid to ask questions such as why not, does it apply to me? Or even to say, I simply don't understand. You're going to have to tell me in plain language what that means. That's really important to me as a lawyer. Can we have the next slide? Thank you. I am going to say that what I'm going to do here is provide you with legal information. This presentation is not legal advice. I don't have the same chance that I do if you were sitting in my office privately, of talking to you, of getting all the facts. Each situation is unique. I thank each of you participants who've sent us questions in advance, because they've really helped me prepare my presentation to know what's important to you. But I'm not giving you distinct legal advice. I need to know specifically with each client what their situation is before I can actually give you legal advice. So I'm giving you information today, which hopefully helps you plan a little more thoroughly the questions that you have about these various topics. Next slide, please. One of the questions related to parenting time and conduct orders and mediation. There's a couple of acts that deal with parenting time. One of them is the Divorce Act. That only applies to you if you're married. The other act is the Family Law Act, and that applies to everybody in British Columbia. The Family Law Act specifically says there is no presumption in favor of shared or equal custody. In other words, the courts don't start from an assumption that each of you has these children and they'll be doing 50-50. On the other hand, there is I'll say a bias on behalf of courts, people who work in the courts, mental health professionals and lawyers, who tend to think that if there's 2 good parents, and by that I don't mean perfect parents, but good parents, that they should spend as much time with their children as possible, even if they're living in 2 separate homes. The Divorce Act says there should be maximum contact between divorcing parents and their children, as is consistent with the best interests of the children. So one may say, well, okay, when I look at maximum contact or no presumptions in favor of equal shared custody, what does that actually mean? Could I have the next slide, please? So my own starting point really is when I talk about making parenting schedules, I always say, do you work? And what's your work schedule? Are you assuming that you're going to be sharing custody of the children so that couldn't be perfect 50-50, but maybe it's going to be sharing custody of the children so that roughly speaking, there's almost an equal time of the children being in each parent's home. It's difficult to schedule. I have to tell you that if one of the parents works a 4-on, 4-off schedule, you often find that firefighters or police officers have a 4-on, 4-off. It's not unusual if one of those parties works that kind of schedule to have parenting time follow that schedule, because it usually means this is when mom or dad is not working and is available to the children, and it doesn't follow a Monday to Friday or weekend kind of pattern. I'm going to say, and I don't mean any disrespect to judges on this, you're at a disadvantage if the judge has to make a decision on parenting issues. They don't know you, they don't know your partner, they don't know your children, and you don't know the judge until the day of your hearing. And there's a limited amount of time that you're going to spend in court if you want a judge to make a decision. So I would encourage you, and I'm sure everybody else on this panel would encourage you, to think about using some other way other than a judge to come to a decision about parenting time. Can I see the next slide, please? So, things to consider. This is work that you and your partner can do when it comes to sharing your children. There is no magic in understanding your children and what their needs are. One thing of primary importance when you're making parenting plans, think about what the kids want. I work now exclusively with children, and what surprises me, dumbfounds me actually, is so many parenting plans. They've been made in mediation, they've been decided by a judge, or the parents have got together and made this arrangement. They've never once asked their children, what's it like for you? What works for you? What do you want? So the first thing I'd say, which is the last thing on this list, is talk to your kids about what works for them in terms of the plan. Or if you've got a plan in mind, talk to the kids about what they would like, what's important to them. So the things to consider: when are you available to the children? When is your partner available to the children? Does either parent have flexibility in their work schedule? Are you able to start late so you can drive the kids to school? Are you able to end your schedule earlier so you can pick the kids up and take them to their activities? Do any of your children have special needs? Who's the parent that's best able to meet those needs? How are those needs met? Meaning, does one parent have to do that? Or can both parents learn what's needed to support a child post-separation that hasn't been learned before separation? There's a lot of people, tends to be mothers, who say, I do everything. And usually they do everything. They do the organization, they select the activities, they take them to their activities, they hold their kids' hand when they're sick, they take them to the doctor. They do all that kind of organizational stuff. It is stuff that can be learned by the other partner. So don't be afraid and don't hesitate to insist that the other parents start participating in these really important parenting tasks. Who manages childcare? And is one or both parents familiar with the caregivers? Are you the one that always takes them to daycare? Can the other partner do that kind of task? Have they met the daycare givers? Who are the extended family members who are involved in caregiving? So many parents who have very young preschool children have a mom or a dad or an aunt or an uncle who's involved in caregiving. Are those people going to be treating each parent fairly if they're picking up and dropping off the kids at their home? Where are the children's schools? What are the schedules of activity? Who's best available to get them to their coaching, to their team sports? Are you a mentor or a captain of a sports team? What, again, are the children's views and preferences when it comes to meeting these schedules? Next slide, please. Use a calendar. I find that when parents are arguing about parenting time, if they put down on a calendar, when are the pro-D days? When are the family traditions, such as my family always has Thanksgiving? When are the school holidays? When are the religious observances? When are the birthdays? Do you want them to the kids to celebrate both parents' birthdays? Once you put these important dates and school holidays on a calendar, and then you put down what your partner wants in a schedule and what you want in a schedule, you'll often find that there's often a few days of difference in a month between what you and your partner might see as a workable parenting schedule. So work in a real time calendar to see what actually is workable for you. What I find sometimes is some parents who are disadvantaged because their work schedule is perhaps not as flexible can take advantage of pro-D days, as long as they know in advance. So you might have one parent having more school days and another parent having more pro-D days because that time suits their work schedules. Mediation is an opportunity for each parent to hear. If you listen, it's an opportunity to hear what the other parent has to say. The job of the mediator is to help open up what might seem like a very rigid line of communication. So the mediator is there to say, you know, when Tanya says this, Michelle, she's actually saying she wants this. And you might not have been able to hear that before. Next slide, please. There's only one rule in parenting time schedule, and that is what's in the best interest of the children. And of course, that's a very, very, very wide topic. Read Section 37 of the Family Law Act is to see what a judge must consider when making a decision for children. And if you go through that checklist in Section 37 of the Act, and you can find these things on our on the web. So just make sure you look for BC, not for Nova Scotia, the BC Family Law Act. You can look at Section 37 and see what a judge must do and what a judge must think about neutrally when he or she is asked to make decisions on parenting time. That's the work I think both parents are best suited to do for themselves. You can get free mediation sessions. They're offered through family justice centers. And I put the website for the family justice centers. They're throughout the province. I put the website on the slide so you can find that for yourself and make an appointment. Next slide, please. One of the participants today had asked about filing documents in provincial court. We often talk about provincial court. You'll hear the words family court more often. This court does not deal with divorces, does not deal with property or pensions or family debt. Things that a provincial court does, it deals with all sorts of issues concerning children, all sorts of issues concerning child support or spousal support, and it can also give you protection orders, things that would restrain somebody from harming you or hurting you or coming to your house. It used to be, up until March 18th, really easy to file things in provincial court. You went down to the courthouse and you filed a document at the registry and they put a stamp on it and that was it. Now, the courts have been closed since March 18th due to the COVID virus concerns, and the only things that the courts are currently hearing are things that are really urgent. I took my kids to my partner's place and I can't get them back. That's an urgent concern. My partner wants to take my kids to just about anywhere or isn't doing safe practices when it comes to the pandemic. Those things are considered to be urgent. The court is now providing bulletins and updates, and rather than me tell you today what might be a change tomorrow or even next week, I put a website on my PowerPoint here so that you can go on yourself and look at these bulletins, determine what's happening next. So right now, court services are very limited to urgent matters. That will be changing in the next, I think, couple of weeks, but don't quote me, you'll have to find out for yourself, unfortunately. Can I see the next slide, please? So the one question was, you know, I've filed something, I've served my partner, but there's been no reply. Well, when there's business as usual, which is not at all what's happening right now, when there's business as usual, you file and they have 30 days to file something called a reply. And if they don't, you can go ahead and get your order. So when you serve somebody, the first thing you have to do is you have to file an affidavit, a sworn statement in the court registry that proves to the court registry that that person has been served. There's something called an affidavit of service, and that's really part of that opening process that you've probably completed if you filed your application in court asking the court to make some orders. You should, after filing your affidavit of service, phone the court registry and find out what their services are available right now. I really can't give you any other specific advice right now because we aren't in usual times. Can we see the next slide? So what the person who asked the question to us today was asking was, what happens if I file, I serve, and 30 days goes by and I don't get a response? So there may be a very good reason right now why there's no response, and that good reason is because nobody's been able to access the courthouse. So I'm going to say that 30-day time limitation may not apply in your situation, but in normal times, you file something, you serve something, 30 days go by, you've provided your affidavit to the registry, they know there's been no reply. You can go then to the court and say, I want a hearing. And if you get a hearing date in front of the judge, which the registry will give you, then the judge can do a number of things. The judge can make some orders on an interim or a final basis to say, well, I've had no reply. I assume the person's been served and they agree with what you want. The person's been served. I assume that this is the income they earn and this is the child support that should be paid. Or this is the order that I should make that they never come onto your property. So the judge can do a number of things at that hearing where there's no appearance at all. Sometimes, however, orders are made on what we call an interim basis, meaning I'm not sure what's going to happen next. I need more evidence, but I'm going to make these orders now, and there may be orders made finally on a later date. So when there's what we call a default hearing and there's been no reply, you might be able to get the orders you've asked for if the person doesn't file a reply. But beware, once that person is made aware of orders, they often come back to court and apply to set those orders aside. That's why we try to encourage people to go to mediation and solve these problems without using the court process if you can. Can I see the next slide, please? One of the questions that comes up is excluded property. And I can't talk about excluded property without talking about family property. So I think probably everybody knows that if you separate, there is a general rule that property is going to be divided 50-50. So family property is anything you own or your partner owns at the date of separation. Anything. It doesn't matter if it's in your name or your partner's name, it's called family property. So if I own the car and my partner owns the house, it's family property. And could be a pension, could be shares in a corporation, could be cars, investments, cash in the bank, savings, all that stuff, it's all family property. And family property is usually going to be divided 50-50. However, it could be that one of you says, wait a minute, that's not fair. I owned that property before I came into the relationship, or that's my inheritance from my mom or my dad. That's what we call excluded property. Somebody that gave you this as a gift, not your husband or your wife, but somebody that gave it to you as a gift from outside of the relationship, or you had it before the relationship started. It's worth knowing, and I just put this in here in this slide, a pension is family property and it is divided. And the portion that's divided is the portion from the date of the relationship until the date of separation. So what you earned before the relationship started, what you earned after the relationship stopped is going to be your excluded property. Could I see the next slide? So what I've done in the next slide is just cut and pasted from section 85 of the Family Law Act, that is the section that actually tells you what excluded property is. And again, if it's excluded property and you want to make that claim, you have to prove that you owned that property beforehand, or you got that inheritance before or during the relationship. Doesn't really matter. So things in section 85, property owned before the relationship, inheritances, gifts to you alone, not just gifts to both of you for a wedding, for example, a settlement, for example, from an insurance claim, property that's held in trust. Some people are fortunate enough to be the beneficiary of a trust, and property that might have been bought and sold with excluded property, and you can trace that you sold your condo and used that money to buy the family home. So you're going to say, that money that I had in my condo is the excluded property, even though I sold it and used it to buy the family home. So that's property derived from other property. Okay, it's kind of a complicated area. It gets kind of complicating and always worth getting legal advice on, believe me, because it's not easy to describe. It sounds reasonable and straightforward, but it's a little more complicated than what I put on this screen. But this gives you a good start in terms of thinking about the questions that you might want to ask if you've got a lawyer. Next slide, please. One of the questions that came up was about spousal support. And before we talk about the lump sum or periodic spousal support, meaning do I get it just in one big check and that's over, or do I get it month to month to month to month to month to month and it goes on? So before we think about how spousal support is delivered, we want to talk how or whether you're entitled to spousal support. You're entitled to spousal support if you need it. That's one of the largest areas of spousal support. I just need the money, that's all. I can't support myself. The other reason for spousal support is compensation. And compensation often arises when you particularly have a long relationship and you might have a job, but your partner may earn many, many times what you earn. That's a reason for getting spousal support. Spousal support can be claimed if you're in a marriage. That's the usual thing that happens. And it can also be claimed if you've been living in a common law relationship for more than 2 years. So you don't have to wait for 2 years if you've been in a marriage to claim spousal support, but you do need to have been living together for at least 2 years before you can claim support if you've been living in a common law relationship. You also can claim spousal support if you've had a child together, even if you're not married, but there are time limits on that kind of support and time limits on common law, whereas you don't have time limits if you've been married when claiming spousal support. Next slide. Child support and spousal support are related. Madhu is going to be providing you with a whole bunch of valuable information on child support and benefits and taxable income. So a lot of what I'm going to tell you today, she's going to do a much better job of explaining things to you that you may not even be aware of when it comes to taxable income and child support and spousal support. What I want to tell you is that you may be entitled to spousal support. You may very well have the need. You may very well have been in a 20-year relationship, and you may very well have children, and you might be very well entitled to an indefinite amount of spousal support, but sometimes there's not enough income. What we do when we calculate support is we calculate child support first, and sometimes there's not enough income left over to pay spousal support. And that could change in the future if the kids live home or one of the kids goes to live with your other partner. So you have to be aware that sometimes spousal support there can be an entitlement, but not enough income at the time of separation to pay it, and that may change later on. Child support is payable to children if they're under the age of 19 and over the age of 19 if they continue to be dependent on their parents, such as they go to university full-time, or they could be disabled, in which case, if they're disabled, they may very well be entitled to child support for an indefinite period of time. Next slide. There we go. So we talked about not having enough income. In terms of pursuing support. Everybody needs to know there's a free government program run through the government of BC called FMEP, stands for Family Maintenance Enforcement Program. If you have an order or you have an agreement for support, those people will, for free, help you collect it if the payer isn't paying. So then we get to how is that support delivered once we know there's entitlement and we know how much and how long it's going to be paid and how much income you have and how much income your partner has. Once we know all these things, we can predict how much you're entitled to. And there's two, generally speaking, ways of getting it. A lump sum, which means you get a check, one check, and it's a tax-free lump sum payment, and that's the end of your support. That may be very good if you think that guy is never going to pay me or he's going to go to Brazil and I'll never see him again. On the other hand, month-to-month payments, which are probably the more common way of getting support, are taxable income. So if you have earnings from employment and you have spousal support, we add them together and that is your total taxable income. Next slide, please. So that important distinction may be something for you and your lawyer to talk about, or your financial advisor to talk about. Is the payer reliable? Do you need that lump sum of support to perhaps augment providing housing for yourself? Do you have enough income on your own to support yourself? Madhu is going to provide you with some information about tax planning. So I'm going to let her talk about whether or not lump sum or periodic support is a vehicle for you. I will say that one of the important distinctions is, in thinking about lump sum, is the idea that, first of all, you can't go back and get more money if the lump sum is paid to you and it gets exhausted. There's a few cases out there, but it's the exception rather than the rule. The other thing is sometimes there just isn't enough money to pay a lump sum. If you have a lot of assets, a lot of resources, there may be enough money, but oftentimes it just isn't possible economically for parents or for one partner to pay the other a lump sum of support. Next slide. The final slide is about divorce orders. Somebody said, when should I get a divorce order? After a year of separation, you can apply for a divorce order. You don't need one if you live in common law. Once you've separated, that's it. But a divorce order is actually really important if you're married, because a divorce severs or dissolves your marriage relationship. Once you get a divorce, you have no more legal relationship with that stranger that you were in an intimate relationship with for 25 years. It tends to dissolve any rights and obligations except for support owing to each other. And so if you're a spouse and you're thinking of divorce, it's absolutely not only important but essential that if you have any property rights, pension rights in particular, because pensions are family property, it's very important and essential for you to get your property rights settled in a final order or agreement before you get a divorce. The only thing a divorce allows you, technically speaking, it allows you to marry again. And most of my clients say the last thing they want is to marry again when they're involved in the chaos of getting separated. So think carefully before you get a divorce. It could eliminate some important rights that you have as a spouse. I think that's my last slide. Is it, Tanya? It is. So thanks very much for your patience. And as Carolina said, there's some time for questions later in this presentation.
Great, thank you so much, Phyllis. Some really in-depth answers there to some of the questions, and some other things might come up for people as well. So thank you very much. And let's go straight into Madhu's presentation.
Hi, everyone. Thank you for being here. And I know it's going through it myself. It's so hard getting information. Most people just want to dig their head in the sand. And so really congratulations for even coming here and empowering yourself with information and knowledge, it's huge. And am I able to share? Hold on a
Yes.
second. Sorry, I should know this a little bit better, but where is, I can't find my share button.
At the bottom bar where it says share screen, and it's a green button.
Ah, now I see it.
Yes.
Sorry about that. And I'm just going to make it into a. So first of all, just housekeeping. I do have children running around in the house, and they've been instructed to stay away from this room. But in case I do get disrupted, I'd like to apologize in advance. And so I'm going to. I've called this presentation like a financial journey through divorce. And what my intention is to give you enough information so you can ask the questions and really think through what it means financially. What Phyllis said is so true, because this is a business and you must consider your separation almost like a business deal. So you can make these important choices, these decisions based on what's really important to you. So the way I've structured it, I've sort of walked through the process of what you need. We'll talk a little bit about asset division, support, and some of the benefits that you have. So my first slide, like what I really want to ask you to, or invite you to think of is, what are your goals for yourself after your separation? And that's really important, because unless you know where you want to go, it's very difficult to navigate and know what choices you're making, what negotiations you're having, what's really good for you. So it's the plan that Phyllis mentioned, that you must have a plan for your separation. And you could think of things like, where do you want to live? If you're working part-time, would you go back to work full-time? What are your options? What kind of life would you like? What activities will your children do? What about their education, retirement? Like, think of it as your own personal plan. Chances are that you don't have a financial plan for yourself right now as a couple. Actually, many couples don't. But this is your opportunity to start again. And you can start setting the foundations from this stage. But what I would ask is, be flexible, because you might have it in your mind that you really want to live in this family home. And then as you go through this process, discover that you're unable to afford it. So be flexible. Things can change. It doesn't have to be bad. But having an idea is really important. And some of these goals that you have, they'll also allow you to see, which battles you're going to pick, what are you willing to walk away from. Answer questions like lump sum versus, monthly support. So what needs to happen in order for you to get your final separation agreement? Financially, your assets will be divided, and then you'll come to agreements on support, both child and spousal. What do you need to do now, or where do you start? Well, for one, you should identify your separation date as well as your date of cohabitation. That's the date that you agree that the relationship is over. Why it's important for you now is that all assets that are accumulated during the relationship are considered family assets, and all debts accumulated are family debts. So if you have if you've come to an agreed upon separation date, and then a month later, one party decides to go on a big holiday and puts $15,000 on the credit card, that is after the separation date. So having that conversation is important. The next big one is gathering information. You're going to need a lot of information. It's going to be your entire life that you will need to put together from a financial perspective. And it sounds easy, but in my experience, that's one of the most challenging areas that people find, just putting it all together, lumping it down, writing down, gathering statements. So for both you and your partner. So, get as much information, start gathering all of that. Understanding your post-separation expenses. When you go to lawyers and when you're having consultations, we're talking about how much your child support is going to be and spousal support, but really understanding what is it going to cost for you to live. Are you going to rent? What are the way I structure it with many of my clients is divide them into fixed costs, the cost that you're going to have. Then in the next slot can be a variable cost that you have some flexibility on, like groceries, and you could live up in different ways. And then your costs related to your children, because some of those will be shared. And then, of course, informed CRA. And this is another area where I find, people have been separated for 6-7 months and they haven't agreed on things. Whereas if they had actually called up CRA, and which they do, and they always get the lump sum back, but they would be eligible to get their child tax benefits, and and it's helpful. So you don't have to wait. You need to wait for 90 days, or you can call them up, but they will give you your benefit after 90 days, and they will prorate it back to your separation date. The next slide, I just wanted to talk about asset division. What is family property? So as Phylllis said, anything that's accumulated during the relationship, regardless of who owns it, is family property. All debts accumulated in the relationship are also family debt. So it doesn't matter who has the line of credit or whose name the credit card's on, it's all family asset and family debt. And your family net worth is the difference between your assets and your debts. I won't get into too much information about excluded assets, as Phylllis has already covered it. But the one thing I want to add to what she said is that while the original value of these assets is excluded, the growth in the value during the relationship is considered a family asset. So what that would mean is if you are, sorry, Neil, you got to leave. You can't be here. I'm so sorry. Bye. Sorry about that. So what it would mean is, like, for example, if you're, if you have a house that you brought into the relationship, or your ex or your partner brought in came with a property and you held it for 5 years, what the original amount of that property, the value would be excluded. But if it grew from $500,000 to $1 million, that $500,000 is to be shared. And that often requires you to go back and trace the values. You might need appraisals, current as well as old. So, getting all that information is important, which is my next slide on asset division, that it's really important to, just dividing assets is one thing. Coming up, if you have RSPs and shares and stocks, they're pretty easy to get the valuations on. You can just print out your statements. But a lot of assets that your family has, they're not as simple. For example, property, you would need either appraisals or assessments or whatever you agree as a family. Pension is really important, especially if it is the intention of one party to pay out as an equalization, their pension payment as an equalization payment. That pension needs to be valued by an actuary. The statements that you get do not give you the accurate values. And then businesses, in some situations, many situations, a business may require a valuation. And again, all of these, except for maybe pensions, there is a little bit of range, and what that, different people valuing businesses might come up with different results. But it's something that just to be aware of, which is what an equalization payment is. So, like, in reality, not all assets can be divided 50-50. You may, things like property, businesses, pensions, or well, pensions could be, but vehicles, they cannot be, you can't just divide them. So an equalization payment is the money that the spouse with the higher total has to pay the spouse with the lower total. And I can just give you an idea of how that would work. So if you just look at this slide, this is just an example of a family with it's fictional. This particular family has a home worth $600,000. They obviously don't live in the Lower Mainland. They have a mortgage and a credit line, and these assets are joined. And then each spouse also has some certain assets in their own names, like RSPs, vehicles, as well as a car loan. The pension here, the value of $200,000 is, in this slide, I've just assumed that they've got an actuary to value it. And even though the value has been put as an asset, it's really, it's not a physical asset that's available to this particular spouse. So if we add it all together, the total family assets are $744,000, which means each partner is entitled to about $372,000. Now, there are so many different ways that can happen. And that's where, you must go back into your goals and to what is important to you. So, for example, if one person might want to buy out the other person's share and keep the house, or one might take on all the RSPs. Of course, there's tax implications there, but there are different things that can happen. There are a lot of different ways assets may be divided, and it can get complicated. And to complicate it even a little bit more, there might be certain assets that have taxes associated with them. So if you have two properties and your plan is that each of you is going to keep one property, if you have one primary residence and another property, it's very the second property may have capital gains tax associated with it when it's sold. So that should be considered when you're dividing assets. If you have corporations, if you've got money sitting in a business account, it's not the same thing as money sitting in your personal checking account, because when you take that money out, there's going to be a tax that, it must be paid out as income. And similarly with RSPs. A few more things to consider. If you and your spouse have RSPs and locked-in RSPs, they have different rules. RSPs are flexible, locked-in RSPs are not so flexible. You're not allowed to access them until you're 55. There's limitation on how much you will be able to take out. If pensions, whether the pension is going to be split at retirement, or if it's going to be if there's going to be a buyout that's happening at this stage, the pension must be valued. And finally, if you are looking at if it is your goal or your aim and your hope to buy a property, then you will need to qualify for a mortgage. One of the things that I've added here is the first-time home buyers plan, which was originally available to people who, first-time home buyers. The 2019 budget extended that to anybody who's separated. So you are entitled, you can use that first-time home buyers plan again, which means you can use $35,000 from your RSPs as down payment. And this will even apply if you're going to buy out your partner. You could still use those. So that there's a link down here, which actually gives you all that information. But just having goals and having an idea about what's available, then you can do some research and find out what will work for you as a family and for yourself as well. So again, making decisions that align with your goals, it's important. So now coming back to child support, that's money that's, paid to the other parent. Calculating child support is fairly simple, as it's based on guidelines, and there isn't much negotiation around it. It's based on income, and it's the law. if the one thing to consider is that if children are living with one parent, the other parent will pay support based on his or her income. If your children are living with both parents, then each parent is responsible to pay support. And if there is a different income differential, if one parent's income is higher, then there will be a set-off amount based on the differential. And special expenses. So these are expenses that are not covered by your child support table amounts. These include things like child care fees, medical, dental insurance, additional expenses that I don't know the legal term for it, but I think go beyond providing the house and shelter and food and clothing, which are considered reasonable, would be considered special expenses. One of the things, how special expenses are calculated, they're based on income. So just as an example, if parent A has an income of 100,000 and parent B has income of 50,000, parents A's proportion would be 50,000 divided by 150, which is the total family income, which would be 67%, and parent B's proportion would be 33%. The one thing to remember, special expenses do not, when you're calculating, we don't include child support in that. So child support isn't added onto your income when you're calculating special expenses. Neither is your child tax benefit. However, if you are getting spousal support would be included in your income, and it would be reduced from the parent that is paying the spousal support. And finally, well, not finally, but coming to spousal support, that's the money paid by one spouse to the other. I wouldn't get into details about how, whether you qualify or not. It's that's something that Phylllis has already addressed. But what's usually, we do have spousal support advisory guidelines that suggest ranges for support. And it's typically that is what most family lawyers are using in, at least in BC. They do not provide advice on whether a spouse is entitled to support. And these are advisory and not mandatory. So, if a lot of times when I have clients, they start with printing out this information and saying, well, I'm going to get this much. It's advisory. It may not happen. There's many other factors that will come into play, and that entirely depends on the family situation as well. But one of the things is that spousal support is calculated differently based on different situations. So there is a different formula when child support is involved, and there is a different formula when there's no children involved. And then the other option is to get lump sum support. So just to address somebody's question, which was, what should you do? Should we take lump sum? Should you take spousal support on a monthly basis? It all depends, again, back to your goals. Like I worked with a family recently, and one of the partners really wanted to buy a house and they didn't want a mortgage, and coming to an agreement on a lump sum support amount was something that really worked for them, because it was like, I can get this money, I can buy this home, I don't have any mortgage, I don't have to worry. The advantages of a lump sum, it's predictable. So you know exactly what you're getting, or you know exactly what you're paying. It stops future dependence on or responsibility towards your former spouse. The lump sum payment is final, whereas spousal support may be revisited with changes. And it does not, the lump sum is an after-tax basis. So it's already adjusted when the calculation for a lump sum amount is done, or it's already taking into, it's paid out after tax. So there is no tax implication. It doesn't affect your annual income, regardless of whether you're paying or receiving it. Whereas when you're receiving spousal support, you will be paying tax on it. If you're paying spousal support, you get a tax deduction. From a financial planning perspective, you must make sure that you, if you are receiving spousal support, put money aside because you will have a tax bill at your end. There are ways to, you could be doing RSP contributions or something to reduce that, but it's always good to plan. The disadvantages, of course, is the person who wants to pay may not have the ability to make that payment. And it might happen that they're negotiating a lower amount. And I've seen that happen. The other is the knowledge and the ability. So if you are going to be, if somebody is receiving spousal support and they're getting a lump sum, which would have essentially supported them for the next 10 years, that money needs to last for the next 10 years. If it runs out in the first 3 or 4, your goals won't be met. And that isn't just spending habit, but also, you do need to keep up with inflation, have it at least doing something for you. And well, the spousal support may be revisited. Again, that's an advantage and a disadvantage depending on what side of the equation you're at. Some of the considerations for spousal support is tax. The first one, whether you will be paying tax, which will also reduce, if you are receiving spousal support, it will also reduce some of the government benefits, like your child tax benefit will, because that's income tested. You will be paying a little bit more proportion of the special expenses because, again, that's there. The inflation, that is something that a lot of people forget, that our rate of inflation is about 2%. The money, if you're agreeing on spousal support that's going to be paid out for 10, 15 years, if you're getting $2,000 a month, that $2,000 a month isn't going to be the same 10 years from now. So must put in an inflation component in your agreement, or at least bring that up so that it's be aware of that. Adjustments after child support ends. So if you've got children that are teenagers and you have 2 or 3 years left to pay, and your spousal support is a longer term arrangement, then once the child support drops, your spousal support is going to drop, is not going to be enough. And while you're making these agreements now, that's when you negotiate, well, what happens once the child support stops? The spousal support should increase based on, or be recalculated. The ability to secure a mortgage. So, and that's a big one because banks don't care whether you're separating. They still want to make sure that they will get their money back. And a lot of times you might actually require that additional income or that additional support in order to qualify for a mortgage. And conversely, if you're paying support, you may not qualify for the house that you want to get because it's considered income or it's considered an expense. So, just balancing all of that. I've worked with clients in situations where we worked a combination of lump sum and spousal, so that all the needs are met, but you're balancing them out so that financially both lives can work out. And finally, insurance. So if you are dependent on for the support for a period of time, make sure that there is some sort of insurance coverage. Okay, so I'm going to go over this very quickly. Like, there are going to be lots of expenses. You must think through exactly where you're spending your money and get the right professionals to do the right job. But unfortunately, divorce is expensive. You will have legal fees. You may have fees related to mediation, counseling, appraisals, evaluations, moving out, and getting to the government benefits. There are 2 or 3 different ones that I want to talk about. Well, not benefits, but also tax credits. There's the Canada Child benefit, which qualifies eligibility based on your family income, and it makes a big difference when you separate. So when your family's together and you're filing taxes together, you may be getting very little, but the moment you separate, it would be based on each person's individual income, and that would change. It's awarded to the parent with whom the child or children reside. If the couple have shared parenting, both parties could be eligible. And but you must inform CRA, and because if you don't, then you might get it the following year when you file your taxes. So I would suggest you call CRA and change your status right away. And you can also get an estimate of what that is going to be. There's a Canada Child Tax Calculator in the CRA website, and if you just go through the process, put in the children, what you have, where they're living, put in your income, and it'll tell you exactly how much your benefit is going to be, or estimate it anyway. In terms of tax deductions and credits, the one is the eligible dependent. And the reason I'm talking about this is because when there's going to be so many things that you have to deal with when you're separating, from dividing assets to figuring out support, that the little things also add value. Like, for example, who is going to be, claiming an eligible dependent it could be worth quite a few, depending on, it could be worth quite a lot of money. So in order to claim a child as a dependent, there are certain conditions that must be met. You must be separated for at least 90 days. It's the year in which you are unmarried. So if you get married again, you may not claim. The dependent child is living at home and is basically not earning a lot of money. And the individual claiming is not the sole individual paying support. And this is something where you really need your lawyers to make sure that your child support is worded appropriately, so that, especially if both parties are claiming. A lot of times, if you have two children, usually each parent will claim one child. And if you have one, very often, it may be every alternate year. And the other tax credit, which works out to a fair amount, is childcare deductions. So when you're married, only the lower income spouse can claim that deduction. In the year of separation, so if during the year you've separated, both parents could claim that deduction. And there's some conditions, like, you must be separated for a minimum period of 90 days. They were living separate in December, and the higher income owner actually did make that payment. And something like that, it's small, but it's a big negotiation and a negotiating factor. So if your spouse earned a lot and made that payment and is aware that you're, because otherwise you would go claim it and it may not give you the same benefit. With tax deductions, typically, if you've got lower income, it would reduce, it may not give you the same benefit. After the year of being separated, it's really ruled by who paid the expenses and the amount of time the child was living with each parent. So if the child is shared 50-50, even if one parent made that entire childcare payment, he may not deduct the entire 100%. He can only deduct for the time the child is living with him or her. So again, my last words, think of your separation as a business, use the right experts. The more clarity you have, the more likely you will, the less you'll spend, because confusion really costs money. And finally, if anybody ever wishes to work with me, I work directly with individuals and families, either jointly or individually. And I also have a online toolkit, which is a financial divorce toolkit, which goes through the financial side in pretty much every topic. And there is a coupon code that's available. Thank you. And I can stop share.
Great, thank you so much, Madhu. I know so much information, valuable information presented there, but that's wonderful. And I understand that presentations will be available later on as well. So thank you. I wanted to ask if any of the presenters wanted to add anything after hearing the others, or if there's any aspect you wanted to touch on a bit more, feel free to go ahead. Carolina?
No, I just would like to say that it's overwhelming, a lot of information for sure, emotional support, legal, financial, and feel free if you want to ask some questions using the chat that we have here, or send your question by email. We can answer later as well.
Great, thank you. That's right. Phylllis, did you want to add anything?
No, I want to thank Madhu for following up so thoroughly on some of the, especially the spousal and child support issues, which are really such important issues to most people. A lot of people don't have property to divide, but most families with children will have child support or child tax benefit issues that are incredibly important. And thank you for mentioning the support, child support or spousal support guidelines, which tend to map out what you would be entitled to if you prove entitlement. And also for mentioning the fact that excluded property that you can claim as yours and shouldn't be divided would not include the growth, which is something that I should have and didn't mention. So that idea that if you had an inheritance of whatever amount it would be in 1997 when you got married, if it remained invested over a period of time, the growth on that inheritance would be shared, assuming that there's going to be growth in an investment account. So thanks for pointing that out, Madhu. I appreciate that.
Yeah, that's great. I was wondering too if I could ask any of the panelists who wanted to comment, just to maybe touch on the issue of high conflict separation situations. And I know one question was posed about you know, threats that can be made sometimes during separation, and hard to, you know, decipher between what is a threat that is real and could be acted on, or what's being used to sort of leverage during a separation process. And if the, you know, the presence of abuse or family violence is there, you know, what considerations can be made, either in terms of, you know, protection orders, or you know, what's available either under the law, the Family Law Act, or from an emotional safety perspective, or even financial implications, if any of the presenters wanted to comment.
Well, I can certainly start on that one, because I think the idea that there's threats in and around separation, and what those threats are so common in every separation, that I think it's a very, very common position to be in. So you do want to find support from both your community as well as your therapists with respect to processing those threats. Secondly, I think you also want to, sometimes it's difficult to do, but you want to step back and analyze those threats. Why is my partner threatening to take the children, for example, which is one of, you know, surprisingly enough, worst but more common threats. So first of all, you ask yourself, is my partner threatening to take the children because they don't want the relationship to break down? Because often people literally stay together because of the children. The other issue is that is the threat more malicious and coercive and controlling? Is somebody trying to, you know, in a very manipulative way, diminish your own level of functioning in order to gain some advantage over you? And the Family Law Act is particularly alive to the idea that if you're negotiating a fair agreement, we have to make sure that there's a power balance between two people. If you're going through mediation, you may very well need the support of a lawyer or an advocate or other kind of support person, even though that's a voluntary process. You may need to pay for legal fees so that you have nothing to do at all with your partner. You may need to get orders to exclude your partner from the family home, which is difficult to do, but it does happen. So I'm going to say threats are there, and you need to tread carefully, but you also need to be objective about the nature and extent of those threats. Some of those threats are simply a cry for help, a cry not to have this separation process happen. Some of these threats are a pattern that existed throughout the entire marriage and are meant to both manipulate and control you. Those coercive threats are more a concern of the courts, and that's where you'll often find yourself looking for legal advice to manage those threats.
Thank you. Any other comments? I did want to mention, as Phyllis was saying there, if this has been an ongoing pattern in the relationship, you know, there are obviously supports out there on the North Shore. There's the North Shore Crisis Services Society, which operates a 24-hour crisis line, as well as a transition house for women and children. There is Hollyburn Victim Services, which provides a range of supports from a community-based perspective. Of course, in the most in cases where, you know, violence is imminent, you want to call the police and dial 911. You can always call the North Shore Women's Center or send us an email to discuss your situation and find other opportunities for support as well. So, you know, please know that if this has been occurring in your relationship, whether it's financial abuse and control of money, or emotional abuse or physical abuse, there is support and assistance available, so you don't need to feel alone. But that if this has been continuing over a period of time, it's very important to create a safety plan. As you know, just as you would be planning for separation, creating a plan to leave in cases of high conflict and violence is also important. So a victim's services support worker can help you to create that as well. So yeah, there are supports available. I don't see any questions on the chat. Tanya, is there anything that you've seen come up at all?
No questions have come through. This is a good time. If anybody would like to ask something for our presenters, they could type in their questions. Maybe everybody had their questions answered. Somebody does have a question regarding student loans during the marriage.
So student loans may be that were taken out during the course of the marriage. Did anyone want to comment on that? I suppose in terms of you know, liabilities, and how do you divide those types of liabilities, debts that have accumulated?
So I'll jump in there. You know, my sense of things is the person is asking whether or not those are going to be shared debts. And I think it really depends on when those student loans were incurred. If you went back to school during the relationship, during the marriage, and incurred that student loan, then because you agreed that it was important that you get an education and get a job and contribute to the income earning potential of the household, then I would think without question those student loans would be a shared or shareable debt, or a debt to be accounted for by both parties during the relationship. On the other hand, if you came in to the relationship with a student loan because when you finished university, you then started to, you then got married. Then if a portion of that debt still exists when the marriage breaks down, I would tend to think the debt would be on your side of the ledger alone. You know, this is kind of one of those questions where you always feel, gee, I'd like a lot more information. I'd like to have a discussion with the person to see, you know, what the impact of that debt would be. You know, sometimes things like debts can impact issues like spousal support. You know, in other words, a person might get more spousal support if they're burdened with a particular debt. So there's no one way of answering that question without really knowing the big picture.
So Phyllis, our participant was mentioning that her ex-partner was in school for a number of years and she supported him. So the student loan is under his name. And the question is if he can force her to pay it too.
Well,
basically.
Was the loan incurred? Did he take out the loan during their relationship? And was that part of the plan?
It was during the marriage.
You know, I'm going to say yes. It could be shared, but one of the questions I'd be asking is there any property that they accrued during the relationship? I'd answer the question yes or no, depending on whether or not, I mean, if they're coming out of the relationship and no property?
No property.
Okay, so if there's no property, then I think I'd have a different answer. Then I kind of say, well, look, that's his or her, that's that person's debt, because it relates to an education which presumably they pursued because they're going into a job market which is going to give them an income. So I would say with no property, that would be one person's debt. If there was property and the debt was incurred during a relationship, I might look at it a different way. So you know, I'm kind of two minds on it. It's always sort of a question of, you know, what am I hearing when that person tells me he's trying to make me share his debt? I guess I'd really want to know how much is the debt, and ultimately, is there a benefit from that debt that person's going to share? So let's put it in a different context. Let's say he had a Visa card, and with that Visa card, he bought the sofa in the living room. Well, you know, the sofa might not be worth as much as you originally paid for it, but at least you've got a benefit that you can say, well, why don't you keep the sofa and the Visa card debt and leave me alone? With an education, you don't have that similar sort of trade-off. So I think you need to look at the bigger picture and say, what is that person walking away from if they're keeping that debt as well? They're keeping the benefit of their education and they're also paying the debt. And there may be other things at play here, which could be spousal support or child support. So we kind of have to factor all of those other things, non-property issues, into that debt payment.
Yeah.
Thank you.
Okay. Thank you. I think we're going to move on because we have a few other questions that have come in. One is are there any time limits for separation before divorce?
There's only really one separation. If you want to get divorced, you have to have been separated for a year. And that's really what we call a no-fault divorce. You don't have to prove anything other than it's been a year. That's the end of the issue. If there is cruelty or if there is adultery, then you don't have to wait that year. But you know, frankly, as I say, the divorce itself only allows you to remarry. That's the benefit of divorce. On the other hand, the point I was trying to make in my presentation is you may dissolve some of your important rights. So oftentimes it takes a year to get to the point of putting any kind of settlement on paper. And I'd say get your settlement first, then look at how much time you need to wait to get your divorce.
Yeah.
We have another question. Participant is asking that if they receive spousal support and in the future start to earn more income from their work, would that affect the amount of spousal support they receive?
Possibly. I can't say for sure. It really depends on what the wording of the agreement or the order is. There are cases out there that recognize that an increase in income may very well entitle the recipient to more support. There are also some cases that say, well, if he was doing this, you know, during the marriage, but he's now got a new job that has absolutely nothing to do with the job he was doing during the marriage, you may not be entitled to that automatic increase. I think also we have to look at how much time has gone by, and if the payer is earning more income, then I guess I'd also be asking, is the recipient under an obligation to engage in more income? Because we look at, when we look at spousal support, we look at the incomes of both parties. So the answer is a solid maybe on that question. And again, I need to know a lot more about that person's economic future when it comes to revisiting spousal support.
Thank you.
Thanks. Another question for you, Phyllis. It came in about whether you recommend recording voice or journaling about circumstances of verbal abuse in the relationship.
That actually is a more difficult question than you might imagine. Recording people who don't know they're being recorded is not necessarily going to be welcomed if it appears that you're trying to entrap them. But it may be the best evidence that you can get. So in other words, if there's a whole bunch of provocation out there and finally that person explodes in anger and says, then the recording goes on, I've told you 1,000 times not to, it may sound like that's verbal abuse, but in fact, it may have been preceded by the usual marital argument that wouldn't necessarily raise anybody's attention. So recordings can be useful, but they also may be seen as provocative. So I think you have to be careful. Journaling, our Court of Appeal, when it comes to putting things in journals or putting diaries into evidence, can be frowned upon because it tends to kind of perpetuate the kind of thing that Carolina was talking about, which is pushing the reset button, getting better, getting healthier. I would say that if you have to write it down to remember it happened, I mean, really, what are we talking about here? I find that, threats and a pattern of coercive and controlling behavior is kind of indelible in most people's memories, and you may not have to commit to writing it down in a journal. So before I started to do something like that, I guess I'd probably be talking to my counselor about what you hope can be achieved. Is it something that you think you need to take to court? But granted, those recordings can be valuable evidence. So, as I say, difficult to know.
Mm-hmm. Yeah, it's a complex question. Okay, thank you, Phyllis.
We have another one. Participant is asking, I will be filing for sole custody as I have been the primary guardian of our son since he was 9 months old. Father moved out to the US and has done regularly, weekly, bi-weekly visitations since. So it isn't exactly a question, but more of a, I suppose, what do you think about this? What would somebody like to comment on that?
I can comment on it. Where it really depends whether or not this person has actually filed anything at this point in time. Right now, our Family Law Act in BC has done away with the words custody, although we still use those words because everybody kind of understands them and kind of knows it means the kid's living with you. I've got custody. Our Divorce Act uses the words custody, but as of, I'm pretty sure it's going to be July, the Divorce Act is also going to be getting rid of the word custody. Instead, what these acts are looking at is talking about people being guardians. And guardians, generally speaking, are people who are the parents, meaning before and after the separation, if you're the biological parent, you're also going to be a guardian. And guardians have both rights and responsibilities in terms of raising their children. So when this person says, I'm going for sole custody, I think what that person is saying is, I want to be the one making all of the decisions with respect to this child because I always have, and he's left the country. So it may very well be that that would be a reasonable position to take if that parent has nothing reasonable to contribute to this child's upbringing, and the parents have a history of lack of cooperation or a lot of, as Michelle said, high conflict, hostility, exchange, et cetera, et cetera. But I think if I'm going to say anything, I'm going to say that there is a trend to some degree that both parents at some point in some fashion would share some of the responsibilities of bringing up their son. So the fact that father doesn't live here wouldn't stop you from asking him for child support. So if you want him to be an economic provider, then in return, it's not unreasonable for him to say, I want to have some measure of influence over my child's upbringing. So I think that's all I can say about that.
Thanks, Phyllis. There was actually a follow-up question right below saying that she doesn't think there will be any issues with asset division, child support, but perhaps custody if he gets emotionally reactive about it. And then what's the best way to file for divorce?
You know what? That's one that I'm going to say they would have to discuss with their own lawyer about that. It's one of those questions that really involves a strategy. And I think that I would prefer for them to ask that question of their own lawyer, because I think strategy is a really big picture question, and I don't know the big picture in this one.
And Phyllis, can I ask too, in terms of securing a lawyer, there's possibilities of having unbundled services as well, isn't there? If it's not an option to hire a lawyer on a retainer, you could hire a lawyer, meet with them, and discuss specific aspects of your separation that you wanted assistance with.
Yeah. So what Michelle means by unbundled services is this a concept that really has become more popular, I'd say, in the last 5 years or so. And what it means is you would go to the lawyer and say, look, I can't pay for the whole enchilada, but I do need somebody to listen to me and help me file a paper that says I want sole custody or sole guardianship. What's the best way of doing that? And so that lawyer would help you draft all the papers that you want to be filed. You'd sign them, they'd file them, and that would be the end of your lawyer bill right there. And then sometime later, if there was a contested hearing about something, you might hire the lawyer to appear for you at that hearing. But it wouldn't be day-to-day, correspondence and letters and meetings and the kinds of things that really lead to healthy legal fees.
Yeah, thank you. And just a quick follow-up too about a question about serving divorce papers to somebody who's living abroad.
Well, when you say living abroad, I don't know where you mean.
I think U.S. I think it's the same.
Yeah. In pretty well every place. Well, especially if it's in the United States. Pretty well every place that I know of, there are people, what we call process servers. And a process server is, usually it's the guy, I'm going to say the guy that takes your filed court papers and serves your partner. And they know what to do. They have, rules and ethics around what they do. Or sometimes you might hire a law firm where that partner lives, and that law firm might undertake to have them served. It would be a more expensive option, but process servers are people who are paid here and in the United States to serve that person.
Great, thank you.
We have a question here. I think it might be for Madhu. Let's see here. So if my husband received money from his dad from selling the family home, and it was put to pay off the balance of our mortgage during our marriage, could the asset from dividing the house's value be excluded? Oh, Madhu is muted. Just a moment. I can't unmute her.
Okay, hold on. I got it.
And I think I just muted her again. Sorry.
Okay.
Okay, we have you back.
Sorry. So the question was that the husband received something from his father, and then he put it towards his mortgage. As far as I know, and again, I'm not a lawyer, so I don't give legal advice. I would, as far as I know, I think it would be considered excluded since it can be traced back. But that's something that maybe Phylllis can add on a little bit.
Thanks, Madhu. I see you kind of sort of frowning like you might not quite understand the question, and I feel the same way. I'm not sure that I understand the question because so here's a number of possibilities. If the father gave money for a down payment, I mean, one of the things you might want to look at was that a wedding gift? Meaning it might have come from his father, but it might have been a gift to both of them to start their life together. So that would not be excluded property because it's a gift to both of them. But if the father somehow circumvented that process and, paid money to one party, then maybe it would be excluded property. But I'm not totally sure if I understand the question. When the house sells, the mortgage will be paid off, and so I'm wondering if the father gave money and then took a mortgage so that everybody knew that he'd given that money. Is that?
We're receiving clarification now is coming through from the participant. She's typing in. But in the meantime, I can repeat the question because a husband received money from his dad from selling the family home. And then that money was used to pay off the balance of the mortgage during their marriage.
I'm not sure. That doesn't really sort of clarify things anymore for me. I'm sorry.
Sorry, I thought maybe if I heard
it received money from his dad, and they used that money to pay off the mortgage.
Yes.
Okay, so if that's the case, it sounds like it could be excluded property. Because it might have been a gift, but the fact is the gift went to pay off a mortgage. And if the property was in joint names, the mortgage would be in joint names. Mm-hmm. Therefore, the gift paid off both parties' debt.
We have a little bit of clarification that says that the father moved into a care home. So the home was sold and the money was divided between the kids.
Oh,
and one was the husband.
It was Dad's house that was sold.
Sorry?
Dad's house was sold?
Dad's house was sold, yeah.
Okay, sorry. So Dad's house was sold and money was given to each of the brothers and sisters.
Yeah, so one of them being the husband, ex-husband, and that money was put towards paying off the mortgage.
On their house. I don't know is the answer. I probably want a lot more information than that, but I'm thinking if the money went to pay off their mortgage, I'm still not certain whether or not did the money go to dad as an advance on his inheritance, in which case he might be able to claim that it's excluded property. On the other hand, if the money went to the husband as his inheritance, he might say, yeah, that's my inheritance, that's my excluded property. On the other hand, if the money just went to both of them and dad paid off the mortgage, I don't know, you'd have to see what that financial transaction looked like. Was there a check that said, it went to Joe Blow, or did it go to Joe and Joanne?
It's inheritance.
Yeah. So yeah, he's got an argument for inheritance. And then like any legal issue, you've got an argument for inheritance. But on the other hand, she might have an argument that to give him that credit would be significantly unfair. So there's arguments and counter arguments. So possibly an inheritance and he gets that excluded property. On the other hand, she says it's significantly unfair for him to be able to make that claim. I should get a share of that excluded property. So again, interesting question to, discuss in mediation.
I think just that same individual has said that she had spoken to her husband about working with collaborative lawyers, and that he was angry about the idea of consulting lawyers at all, and so was asked, is her only option at this point to have what she said a non-collaborative lawyer?
Well, yeah, collaborative lawyers are hired when both parties agree that's the process they're going to use. If both parties agree to go to mediation, it happens. If one person says no, it doesn't happen. Both parties agree to use collaborative process, it happens. One person says no. So yeah, she doesn't really have much of an option at this point in time in terms of who she selects, although that doesn't really, most family lawyers that I know are happy to have things settle out of court and do work hard at settlement as opposed to argument, because it's usually the argument costs more than what they're arguing about when we talk about legal fees.
Thank you.
I have just a few minutes left, and there are two more questions that have come in. So let's see, here's one. I heard settlement versus divorce. What constitutes a settlement? Separated for 4 years, nothing official done except CRA.
Well, if you're asking me, a settlement usually means it's an agreement on all of the issues, all of the legal issues that come up when you're separating or divorce. So it could be spousal support or child custody, or it could be dividing property or allocating debt or protection orders. The whole ball of wax. That's usually what people want to achieve, is they want to know what's the final plan that I will sign. And it could be a court order, or it could be just a written agreement that both people sign. A divorce is something you have to go to court for. So you don't have to go to court for a settlement. You can mediate it. You can work through a collaborative process. Maybe you'll have to go to court, but a settlement usually arises outside of court. If you want a divorce, because you've gone through a legal process to get married, which is a legal issue, then you need a legal process to dissolve the marriage. That's what a divorce is. And a divorce allows you to remarry. And that's about it.
Thank you. We have a question. Sorry, Michelle, did you want?
Nope, go ahead.
Okay. Question from Madhu.
Thank you.
If the child goes to private school within the church, every year they claim school contribution as donations. This year, the participant's ex stated that he will be claiming the whole amount. Can she claim half of it? If he already claimed and she will do it too today, will the CRA question them?
If they both claim, then CRA will question them. Because there's only that much that can be claimed. except, I mean, it's a little bit different from, I guess donations are different from, say, childcare. I don't have an exact answer. I'm so sorry about my dog. I'm having a hard time with my kids and dogs. But as far as I know, sorry, give me a second. I think she should be able to claim the portion that she's paid. But if you sort of have that as a question, I can get the exact answer and email it back. And maybe you can provide that information later, just so that I'm not giving out wrong information.
Do you know what the consequences are if both claim school donations? They're both of their names are on the receipts.
Is she claiming the full amount? Or like if you're claiming the full amount and the two people claim the full amount, then CRA will pick up on that.
Half of it, she said.
If she's claiming half of it.
Half. So her portion and half.
I think it should be fine. The problem is when two people claim the same amount and like there's double dipping. But if she's claiming half of it, it should be fine as long, if CRA opens up, you might have to prove that you actually did make that payment. Like, did you, well, he's claiming the full amount. He's claiming the full amount and she's going to claim, well, then, I mean, it might open up and there might be a CRA question. I don't believe they will automatically reject everything. I don't think that's the case with donations, but it is something that they will probably investigate. So, yeah. I mean, if she's made the payment and she's claimed half, it should be fine. But I can check with an accountant and email you back a little bit more on that.
Thank you. We have another, I think the last question. Pension evaluation is done by what type of service provider? It was mentioned, but the participant forgot.
Actuary.
Actuary. I think that concludes all of the questions and just enough time for us to wrap up. And since I'm talking, I'll continue. There was one thing I wanted to mention that I'll be sending a follow-up email to all of the registrants, which will include all 3 of the presentations because there's some resources in there. I will have a sign-up form in there for whoever is interested in joining our separation support group with Carolina. So you'll be able to put your name in, and we'll be sending more information about that soon. So if you're interested, you can provide your email and contact number so that we can let you know when everything is set up. And also, we do have a legal clinic that is active right now. We have volunteer lawyers that are doing 1-hour consultations over the phone. Because of COVID, we haven't opened up the center yet. If you haven't seen a lawyer with us before and your income is below $45,000 a year and you're not retaining a lawyer, you could be eligible to see a lawyer with us. So I'll have my contact information in there and you can let me know if you would like to do an intake with us and we can see if we can arrange an appointment with a lawyer. June right now appears to be booked, but sometimes we can get in appointments sooner rather than July that we're looking at. So I will keep you posted, but all this information will be in the follow-up email and you'll be able to contact me with more questions and if you require any other resources. Thank you.
Great. Thank you so much, Tanya, for co-moderating me and all the technical support. And genuine thanks to each of our presenters this evening. Carolina, Phyllis, and Madhu, just really, once again, invaluable information and resources you provided. So thank you so much for that. Phyllis as well, thank you for mentioning as well that we were honored to be able to do and privileged to be able to offer this presentation on the unceded Coast Salish traditional territory. So Coast Salish and Tsleil-Waututh Nation. So thank you for mentioning that. As well, thank you once again to our funders for this workshop, the West Vancouver Foundation. And if anyone, as Tanya said, has any other questions that they want to send to Tanya to info@northshorewomen.ca, And please feel free to visit our website or sign up for our newsletter, which gives information about other activities and programs that we're running mostly remotely at the moment because of COVID, but there are a number of offerings going on there as well. So that concludes our workshop for this evening. Thank you once again to everyone, and we hope to see you again in another program. Take care, everyone.
Thank you.
Bye.
Bye-bye.